Supreme Court reinstates order for retrial of Alabama death row inmate. The U.S. Supreme Court on October 8 lifted a temporary stay that had paused a federal appeals court decision requiring a retrial for Alabama death row inmate Michael Sockwell, convicted of the 1988 murder of Montgomery County Deputy Sheriff Isaiah Harris. The unsigned order ends the administrative stay that Justice Clarence Thomas granted on September 26, which temporarily halted the 11th Circuit Court of Appeals ruling to give the justices time to review Alabama's emergency appeal. The court's new order clarified that the denial of Alabama's request is without prejudice to a reapplication if a new trial is imminent, meaning the state may refile if retrial proceedings begin soon. The 11th Circuit had ruled 2-1 on June 30 that Sockwell's conviction was unconstitutional because prosecutors engaged in racial discrimination during jury selection, violating his 14th Amendment rights. The panel found that prosecutors repeatedly and purposefully struck black jurors they believed might sympathize with Sockwell due to shared race. This decision made him eligible for a new trial. Sockwell, now 62, has spent 35 years on death row. His attorneys claim he suffers from severe mental and physical disabilities and has an IQ too low to qualify for the death penalty. They also argued he has never received a trial free from constitutional error. According to prosecutors, Sockwell was allegedly hired by Harris's wife to kill her husband to conceal an affair and collect life insurance money. There were no eyewitnesses to the murder. Sockwell later confessed but claimed police coerced him by withholding food and water and threatening violence. In Alabama's September 25 emergency filing, Solicitor General Edmund G. LaCour Jr. argued that Sockwell's appeal relied on Batson v. Kentucky, 1986, which prohibits prosecutors from dismissing jurors based on race. LaCour, recently nominated by President Donald Trump to a federal judgeship, maintained that every prior court had rejected Sockwell's Batson claim until the 11th Circuit's reversal. He urged the Supreme Court to maintain the stay, warning that allowing the retrial to proceed could irreparably harm the state's ability to challenge the ruling. Sockwell's lawyers countered on October 3 that the state's arguments were case-specific and unlikely to succeed. They urged the court to deny the stay, asserting that the Supreme Court rarely grants review in such fact-based cases and that Alabama identified no legal conflicts warranting its intervention. With the stay lifted, Alabama may have to prepare for a new trial, marking another major development in a decades-long case mired in racial bias claims and constitutional controversy.